Number 8. Second row on top. The numbers are on the chair. Have a seat.
Oh, which number again? I'm sorry. 5. Let me see.
15. So 15. Okay.
Because I
Oh, bench.
Yes, I have you there.
23. Next row. $39.
All right, everyone, please be seated. All right, everyone, good morning. All right, so it's Monday, I know, but everyone should be wide awake. Good morning, everyone.
Good morning.
All right. Welcome to the 187 District Court. My name is Judge Stephanie Boyd. You're on the 4th floor and you're in the 187th District Court. So what floor are you on? What courtroom?
187.
And who's the judge? All right. And I see people smiling and I know people are wondering, why would she ask us that? Of course, we know where we are, but this is what ends up happening. Sometimes we'll take a break. And when we take a break, everyone has to leave the courtroom. And it has never failed that when everyone leaves the courtroom, sometimes people get lost. And so if you're ever lost, when we take a break, you can either remember 187th or you can remember Boyd. I'm the only Boyd in the entire courthouse. And the 187th District Court is the only 187th District Court in all of Texas. So someone would be able to tell you where it's located if you get lost. To my left is the court reporter. I always said if ever I was in a position to make someone's job easy, I would do my best to do that. So in order to make her job easy, this is what we need to do. Number one, the pace that I'm speaking at right now, if everyone could please speak at this pace. If you were to speak faster, of course, she would be able to take it down, but it will make her job so much easier if everyone would speak at the pace that I'm speaking at. The other thing is that everyone speaks one person at a time. It's easy to get involved in sort of like conversations and everybody's speaking all at once. But if you can imagine, if everybody speaks all at once, she is not going to be able to take it down. Now, when I asked you the question, where are you? And everybody said the 187th, what she put down was Vernier panel states 187th. So if we could do that for her, that would make her job easy, or I should say easier. In your possessions, you have cards. Could everyone please raise their cards and keep them raised till I ask you to lower them? All right, so everyone in the box, if you could lower your cards, please. Jurors 15 through 21, if you could lower your cards. And I'm sorry, 22. See, I was saying if you were listening. All right, everyone else, if you still have your cards raised, when you are answering a question or have a response to something, if you're able, if you could please stand when you do that. We are in this court in jury trials once a week. So far, no jury has been able to follow that instructions. And I always tell the jurors, but I have faith you can do this. So I have faith that you all will be able to do that. So if somebody forgets, if you will tap them, that will be great. And the reason why I'm asking you all to stand when you all speak is because the acoustics in this courtroom are not very good, and that will make it easier for the court reporter to hear. So you all can lower your hands and your cards. All right. So this case is the state of Texas versus Jose Ruiz. I'm going to have the parties introduce themselves to you. State.
Hi, I'm Brittany Mitchell.
Morning, I'm Marissa Giovenco.
I'm Allie Jackson.
Defense.
Good morning, I'm Teresa Connolly, and I'm not related to April, right? Thank you.
Renee Munoz on behalf of Mr. Ruiz. Good morning.
Good morning, Lorraine E. French for Mr. Ruiz. Thank you.
And if the accused can introduce himself.
Sir Ruiz.
Right.
We also have Kara Polk, and another person who's coming is Robert Gajunas, who's gonna help with jury selection.
All right. So what I can tell you is this door to the back of me, it has a sign outside of it that says, we're in jury trial. Do not come through this door. You're going to see people come through that door because they don't read the sign. People who come through this door are staff. It's not related to this case at all. Sometimes there are documents for me to sign for other judges, or sometimes the staff have other things for me to take care of. Now, you have some people here. Sometimes we have students who want to see a jury trial, and they're thinking about entering the field of law. So you'll see them observe. And then sometimes there are attorneys who just want to observe. All right. So the parties have introduced themselves. Is there anyone here who recognizes or knows any of the parties? Raise your card if you do. All right. Now, when the state talks to you and when the defense talks to you, they are going to be talking to you in hypotheticals. So when they're telling you things, do not start thinking, oh, this must be about Mr. Ruiz, and these are the facts in this case. You will not get a chance to hear what parties thinks the facts are in this case unless you're selected for the jury. So remember, all questions that are being asked of you, they are all hypotheticals. Now, the charge in this case, there are different counts. They're all sort of related to the charge of injury to a child. Some of them are first degrees, some are second degrees, some of them are third degrees. And I'll come back to that in a moment with you. Now, how does somebody get to court in a felony case? It's through an indictment. How many people here have had a traffic ticket? I'm asking you to start practicing raising your cards. Raise your cards. All right. So what this tells me is that San Antonio does have a lot of bad drivers. You can lower your car. All right. So I've had a traffic ticket in my past before. I've had one traffic ticket in all of my lifetime. So I'm only 21 though. So yeah, that shouldn't be that funny. All right. So when I received a traffic ticket, that was back in the day where they gave you a piece of paper and they had to write it down, and they had a book filled with tickets where they wrote it down. So let's say you get a traffic ticket, you get pulled over and they say it's for running a stop sign. And you take the ticket. Your accepting of that ticket is not saying, you know what, you're right, I did run a stop sign. That ticket is to tell you, this is what you're being charged with. And usually at the bottom, it will tell you where you need to appear to answer for that charge. That ticket is not evidence of guilt. Does everyone understand? So with an indictment is similar to a traffic ticket, and by it tells you what you're charged with and where you need to be to answer for the alleged charges. It's not evidence of guilt. It cannot be used as evidence of anything. Does everybody understand? Is there anyone here who will hold it against Mr. Ruiz because he's here by indictment? Next thing I'm going to talk to you is certain rights that people who are accused have. One is a right to remain silent. So what that means is you don't have to give testimony. I've been a defense attorney. I've been a prosecutor. Sometimes my clients, I would tell them, look, it's your right to testify if you want to testify, but you really don't need to testify because the state hasn't proven their case. Other times there may be my client is extremely nervous because, believe it or not, everybody gets nervous when they have to testify. And sometimes it will be a case of me telling my client, look, I tried to get you not to be so nervous, but you're going to be nervous, you're sweating, and I'm the only person here. Maybe it would be in your best interest not to testify because maybe people will think you're guilty because you're nervous. Or sometimes you have people who stutter, or people are just too afraid to take the stand. The key is, under our Constitution, everyone has a right to remain silent. So what that means is nobody has to testify. Is there anyone who's going to hold it against Mr. Ruiz if he decides not to testify? All right, the next thing I want to talk to you is about presumption of innocence. Everyone who is charged with a case is presumed to be innocent. So what that means is right now, if you had to vote on whether Mr. Ruiz were guilty or not guilty, your vote should be what? All right, let's say it louder. What should your vote be?
Not
And the reason why is because everyone is presumed to be innocent. So the only way to find somebody guilty in a criminal case is the state has to prove their case beyond a reasonable doubt. And they have to prove each element beyond a reasonable doubt. Now, what I can tell you is there used to be a definition for proof beyond a reasonable doubt. When I had my first jury trial many moons ago, you had to know the definition. And you felt like such a failure in law school and trial advocacy if you didn't know the definition. I knew the definition. I still know the definition. I knew it backwards and forwards. I knew where to put the comma. I knew where to pause for dramatic effect. Had my first jury trial. Guess what? After that first jury trial, the powers that be decided that there is no longer a definition for proof beyond a reasonable doubt. So there is no definition. So neither state nor defense can give you a definition because one does not exist. So when I would try cases after that, I would tell people what it was not. Next door, you have the historic courthouse. That's that building with the green rooftop. Over there, they try civil cases. So the money cases, maybe the fender benders, their burden of proof is preponderance of evidence. What does that mean? More likely than not, something happened. So if you're ever in a criminal jury trial and you are deliberating and you start saying, well, I believe this happened more likely than not, you know you are at the wrong burden of proof and you should be on the civil side. So that's not the burden of proof in criminal cases. It's proof beyond a reasonable doubt. The other burden of proof that's next door are your child protective services cases. Their burden of proof to terminate someone's parental rights is clear and convincing evidence. Clear and convincing evidence, that's a high burden because that means that the government is telling you, we can't trust you with your child, so we're terminating your rights and legally you will no longer be their parent. The highest burden we have here is proof beyond a reasonable doubt. Now, I want to talk to you about fairness and what does that mean? Because sometimes attorneys will tell you, can you be fair? Can you be impartial? But really, what does that mean? Because when you came into court today, guess what? You come in here with whatever your past is. Sometimes we have theft cases, for example, and people maybe have had a theft happen to them. And people will always ask, will that affect you? Of course, your past affects you. Your past impacts you. But the question really is whether or not, regardless of what your past is, if you're selected for jury, can you listen to the evidence and make a decision, if you come to a decision, on whether someone's guilty or not guilty based upon what you hear? For example, people will always give this example where they say, well, maybe this is not the right trial for you. You know, what if it's a burglary trial and you woke up this morning and somebody had burglarized your car and the windows are shattered and you come down and you find out it's a burglary of a vehicle case and you just can't sit on that? That's really not the correct question. The correct question is, regardless that has happened to you, whether or not, if you were brought in to sit on a burglary of a vehicle case, whether or not you would listen to the evidence in that case and make a decision on whether someone's guilty or not, because we all have issues in our past. So is there anyone here, if you were selected for this jury, is there anyone here who would not be able to listen to whatever the facts may be in this case and make a decision, if possible, on whether someone's guilty or not guilty? Is there anyone here who could not do that? All right, number 14, 17, 20, and 37. All right. So the next thing I want to talk to you about is phases of trial. There are two phases to a criminal trial. First phase is whether someone is guilty or not guilty. People always say it's whether someone is innocent or not. That's really not the first phase. The first phase, did the state prove their case or did they not prove their case? If they did not prove their case, then the verdict would be not guilty. Does everyone understand? Okay. If you decide somewhere we're guilty, then there's what's called phase two. Phase two is called the punishment phase. Everybody who's accused of a criminal charge must make an election or selection that if they were found guilty, who would they go to for punishment? It's the law. You can't say, I'm going to sit and look at the jury and go through the first phase, and then I'll make a decision on whether or not I'll go to them for punishment. So is anybody going to hold it against Mr. Ruiz? Because legally he had to make a choice of where he would go to if he were found guilty. Is there anyone who's going to hold that against him? Okay. So in this case, Mr. Ruiz has stated that if he were found guilty, he would have the jury to determine his punishment. Is there anyone who's going to hold that against him? All right. Now, the range of punishment in this case. In this case, there are different ranges of punishment. Some is probation. Some is 5 to 99 years or life in prison. Some is 2 to 10 in prison or probation. Some is 2 to 20 in prison or probation. And sometimes when people are not used to being in the legal world, they are shocked by ranges of punishment, right? First-degree felonies. Range of punishment is 5 years to 99 years or life. And in some cases, the possibility of probation. Does everyone understand the range? Now, when you think about that, what that means is you could give somebody probation, or you can give them 5 years, 6 years, 7 years, all the way up to 99 years or up to life. Does everyone understand? Yeah. For second-degree felonies, the range of punishment, possibly probation, or 2, 3, 4, 5, all the way up to 20 years. Third-degree felonies, possibility of probation, or either 2, 3, 4, 5, all the way up to 10 years. So does everybody understand those ranges of punishment? Now, in criminal cases, defense and the state are not allowed to ask you and say, oh, if you were to find somebody guilty of a burglary of a vehicle, what punishment would you give them? They're not allowed to ask that because those are commitment questions. And many times what I've noticed about jurors in my experience is when somebody asks you, can you consider the full range of punishment? The first thing you want to know, yeah, but what are the facts? Then I can tell you if I can consider the range of punishment, or I need to know more information. So really, what this means is this. Do you recognize that that is the range of punishment in this case? Does everybody recognize that? Those are the ranges of punishment.
Yes.
So when we speak of ranges of punishment, the law is for you to consider it, not that you give it. So nobody can ask you in an injury of a child case, will you give somebody probation? Will you give somebody life? They're not allowed to ask that. What the proper question to ask them is, can you consider the full range of punishment? So for example, if you were on an injury to a child case where the range of punishment is anywhere from probation to life, or anywhere from probation to 10 years, or anywhere from probation to 20 years, the proper question is, do you recognize that as the range? And will you be able to listen to evidence if you were to find somebody guilty and make a decision on what is the appropriate punishment? Does everyone understand? Is there anyone who cannot consider the full range of punishment? And if someone were, just 1 second, and if somebody were found guilty, to place facts to your consideration, and if possible, come up with an appropriate punishment. Is there anyone who could not do that? If you cannot, raise your card for me. 1, 14, 49, 61, 62, and 4.
And 4.
I'm sorry? 4. All right. The next thing I want to talk to you all about is languages. I love languages. I think they're beautiful. When I went to college, there were people who could speak a lot of languages. And surprise, surprise, people from the United States, usually you don't speak multiple languages. But I had some friends who were in college. They were from Europe. Some were from the Middle East. The students that were from the Middle East, they usually could speak 6 to 8 languages. I had a friend who was from Arizona. She was Navajo. She could speak Navajo. I never anticipated being in San Antonio or Texas. I'm originally from Louisiana. So of course, when I had a choice between Spanish or French, I chose the language where I would probably be retiring by the age of 21. So that would be French. My best friend said, Stephanie, take Spanish with me. And I told her with a straight face, hey, I'm retiring to France. We're in Louisiana. I'm speaking French. Lo and behold, I end up in San Antonio. Now, mind you, I can say the words hurry up in almost every language because that's what my friends were able to teach me in college. When you're in law school, there's so much going on. You just don't have time to learn all the languages. So I need y'all to raise your card if English is not your first language. All right, number 6, 19, 27, 36, 37, 44, and 69. All right, number 6. What's your first language? All right. Have you been able to understand everything? Number 19.
Spanish.
All right. Have you been able to understand everything? Number 27.
Spanish.
All right. And see, we've already failed. Nobody nudged him to say Stan. That's okay. I'm going to give you all another shot. We're going to pretend like that didn't happen. All right. Number 27. That's okay. What's your first language? Have you been able to understand everything? All right. Thank you. Number 36. Have you been able to understand everything? All right. Thank you. Number 37. And have you been able to understand everything? Thank you. Number 44. Have you been able to understand everything? All right. How long have you been in the US? I'm sorry? Okay. And did you go to school here? All right. Was that high school, college, elementary? All right. Thank you. Number 69.
Spanish.
All right. Have you been able to understand everything? All right. Thank you. All right. The next thing I want to talk to you all is about time constraints. And what do I mean by time constraints? I mean, maybe you have travel plans and you can't put the tickets in my name, something like that. Okay. So I expect this trial to last for 2 weeks. So anybody have any type of time constraints, raise your card now. And once I call out your number and pass you, do not come back and raise your cards afterwards. All right, number 1, 4, 6, 9, 10, 11, 12, 14, 16, 19, 22, 24, 26, 27, 35, 36, 39, 40, 42, 43, 45, 48, 50, 51. I missed 46. All right, 46, 54, 55, 57, 58, 60, 61, 62, and who's 66, 78, 79, and 80. All right, juror number 1, what is your time constraint? I'm sorry, when?
Next Tuesday
And what time?
at 10:45.
All right, number 4.
Primarily work, and my wife travels for her work, so I'm responsible for taking care of my household
All right,
and working.
all right, thank you. Number 6.
Here in the next couple of days, we're gonna start a kitchen and bathroom remodel.
All right, thank you. You know that's not going to start on time, right?
There's so much time frames right now.
Number 9. 9.
Oh, I'm sorry. Work, and I was also summoned for US District Court starting
I'm sorry, when?
March 31st through May 3rd.
All right, are you summoned as a witness?
I have the, I just received it.
I'm sorry, Your Honor, I couldn't hear that.
All right, could you please speak up?
It's for work, and I was also summoned for US District Court, starting March 31st through May 3rd.
All right, so is that district court in this courthouse or is that somewhere else? Federal?
Yes, ma'am.
Okay. Thank you. Number 10,
I have a number of time-sensitive surgeries to perform next week that really can't be rescheduled.
okay, all right, thank you. Number 11,
It's due to my work and I've got 5 kiddos with appointment schedules this week and next week.
all right. So how old are the children?
Oldest is 17 and youngest are 10-year-old twins.
All right, and what appointments do they have?
One is an Air Force appointment for my oldest, scheduled on Thursday, and I have wellness appointment on Friday, and next week on Tuesday for my 13-year-old.
All right, and what time are these appointments?
The Air Force appointment's at 3 p.m. and the wellness appointment's at 9 a.m. on Friday next week. I believe it's at 11 a.m.
All right, so the appointment on 3 p.m., what day is that?
Thursday this week.
All right, and the appointments for 9 a.m., what day?
Friday.
And the last appointment?
Tuesday.
All right, thank you. Number 12,
For work, I have patients scheduled from 8 to 5 for the next 6 weeks, full of elderly patients already scheduled.
all right, thank you. Number 14,
Actually homeschool my grandson that's 10 years old, he's autistic and dyslexic, and I also have clients throughout the week. Anywhere between Tuesday to Sunday, starting at 9 a.m., 10:30, 11:30, 5, and so on.
and the people that you're seeing, do you see them outside your home?
I do not, I do everything via Zoom.
Okay, all right, thank you. Number 16,
a substitute teacher and started the assignment.
Okay.
So I did.
all right, thank you. Number 19,
I have 3.
I'm sorry, what?
3 radiation treatments.
All right, thank you.
I have more appointments.
All right, thank you. I know it's going to go well. Number 22,
I've got, I work at a fire department and I'm the only one that can do my job as public relations, and I've got appointments throughout the week and next week.
okay. And what are your appointments next week?
I'm sorry.
What are your appointments next week?
Oh, they're all, a lot of them are appointments for installing child car seats
Okay,
and various public relations, teaching kids and stuff like that.
all right, thank you. Number 24, so where are the 4 and 6-year-old now? Okay, so is that, you need to be leave by 3? Okay, all right, thank you. Number 26,
I have an appointment next week for 17 checkup.
okay, 8:30. And what day next week?
Monday.
All right, thank you. 27,
Primarily work, Your Honor, and my mom's leaving to Mexico to take my brother to get his wisdom teeth taken out, and I might be staying home to watch my grandfather.
all right, thank you. 35, all right, thank you.
Sorry, I didn't hear that, Josh.
All right, would you speak up, please? All right, thank you. Number 36,
Fatherman and my work schedule won't allow me to do so.
oh, sure. No, let me just explain something to everybody. You cannot be fired from your job because you have jury duty.
Right, I'm a single father, head of household, man, I cannot afford to be.
All right, thank you. 39, all right, how old is your grandson? Okay,
Now,
all right, thank you. Number 40. All right, thank you. Number 42.
Primary first week.
All right, thank you. 43.
Yes, ma'am, surgery.
When is your surgery? What time? All right, I know it's going to go well. Thank you for letting us know. And thank you for showing up even though you have surgery tomorrow. 45.
My wife got appointments on the 22nd of this month, very important for her. Physical, and I got a VA appointment probably.
All right, thank you. Number 48. Okay, I'm sorry. I'm gonna need you to speak up so the court reporter can hear.
During that time, that one.
All right, thank you. Number 50.
And I have a disabled daughter, so she has appointments coming up next week.
What dates are those appointments? What date are those appointments?
Tuesday, week at 1:30.
All right, thank you. 51. All right, thank you. 46. Oh, how long is spring break? All right, thank you.
What was her number?
46. 54.
Or I have on-call, volunteered for one, this Wednesday, and then my regular on-call starts, 25th through the 21st.
All right, thank you. 55. All right, thank you. 57. All right, what college do you attend? I'm sorry? All right, thank you. 58.
Do not get jury pay, and I will have to end up using my paid time off to do this, and I do have a couple plans scheduled that are already paid for down the road, so I would not be.
Oh. All right, thank you. Number 60.
I'm sorry, ma'am, I need you to speak up, please. You take your.
All right, thank you. Number 61.
It's 1:45. And then next Tuesday, I have one for my.
All right, thank you. 62. Yes.
That report at 2:30 on Tuesday. And I've just begun a series of dental appointments, which are going to involve 2 extractions, replacement of the bridge, and I've got temporary already. These are not scheduled at this time, and I'm going to be having the dentist.
All right, thank you. 64.
So do not get paid jury leave.
I'm sorry, what?
I also do not get paid for jury duty.
Okay,
And I am my own provider.
all right, thank you. Number 66.
Tomorrow.
What is the appointment for?
I'm sorry.
All right, and that's tomorrow? I'm sorry. Number 78.
Your Honor, I got a already rupture in my right shoulder. I started physical therapy last week and I go twice a week.
All right, thank you. 79.
Scheduled for surgery on the 20th and I have to be here at 9.
All right, thank you. I know it's going to go well. Number 80.
I have two doctor's appointments. One is scheduled tomorrow for dermatology. One is scheduled for Dr. Watson, my health club the next week. And then after that, Your Honor, I'm going on my 40th wedding anniversary trip to Europe for a month.
Wow.
All right. So
Wow.
on your Europe trip, is that a gift to you or is your husband coming as well?
They're both gonna be on the Viking ship. So.
Oh, that is awesome. Well, congratulations. Thank you. All right. Thank you. All right. So I understand that people have issues that are upcoming. And this is what I always tell people. And I base this upon what a friend once told me. I would never take vacations as a defense attorney. And so my friend said, Stephanie, God forbid something were to happen to you and you were to die tomorrow. He's like, you know what would happen? Okay. I'm thinking, oh, everything is going to shut down. People are going to be so devastated. People are not going to be able to work. And he told me, he said, Stephanie, I will be very sad because I consider you as a sister. He's like, but let me just tell you what's going to end up happening. What's going to end up happening is somebody's going to say, that's so sad. All right, can we get somebody else to take her cases? So I understand that people have jobs and people think they're indispensable. But to be indispensable, what that means is if something were, God forbid, if something were to happen to you, that means that, oh, well, we can't do anything with these people because the person who's not here is indispensable. So just keep that in mind. The other thing I'm going to tell you is two stories. Both of these stories are true. I understand jury duty is an inconvenience. And I say it's an inconvenience because guess what? They call you and they tell you you have to be here at 8 a.m. You think you're going to be late, so you're rushing. And when you rush and you're finally able to find where you need to be after asking people in the hallway and you're running, it's a hurry up and wait situation. And you thought, hey, I'm here at 8. Things are going to be happening right now. And then getting downtown, that's an issue because there are so many one ways. And you see the building and you're like, if I could just turn left or if I could just turn right, it's right there. And then you have to find parking and you don't know where parking is because you're not downtown on a regular basis. Then not only do you have to find parking, you have to pay for parking, and parking is expensive. But I tell people all of this is an inconvenience because your government only asks two things of you: pay your taxes and serve as a juror. And when they ask you to serve as a juror, they're not even asking you to do it every month. There are some people here I know who've never been called up for jury duty. This is your first time. There are some people who maybe been called up twice. So it's an inconvenience when you think of what your government does and what your government asks of you. Your government doesn't even ask you to vote, although I think everybody should vote, but your government doesn't even ask that of you. So you don't have to vote. All you have to do is pay your taxes and maybe once in a blue moon, come up for jury duty. Now, I'm going to tell you, yes.
I just remembered, actually, I'm a musician, so I am going to be on the road Friday, Saturday, and Sunday. So
Oh, awesome. What do you play?
I play pedal steel guitar.
All right. So if something were to happen,
You don't.
there's the band is over. They're not going to be able to find anybody else to do that. Okay. So the other thing, the reason why I'd say it's an inconvenience, let me tell you what a sacrifice is. My uncle grew up in a small town called Grand Cane, Louisiana. Everybody knew everybody. He was my grandmother's firstborn. He's since passed. She's since passed. He would go to school. All the teachers knew him. Super intelligent. When computers came out, he already knew how to work them. So the teachers would pass him from grade to grade because they're like, we've taught you everything we can teach you here. You need to move up so you can be stimulated more and so you can learn more. So behind him came his siblings. One brother, the rest are girls. So of course, all the teachers knew them. And so the teachers would tell his siblings, we got our eye on you. We're expecting a lot because your brother has basically set the mark for what we're expecting from you. And of course, they didn't appreciate that. My uncle graduates and he graduates early. When he graduates, something breaks out. You may have heard of it, something by the name of the Vietnam War. He goes to my grandmother and he says, the only way I could potentially improve my lot in life is to sign up. Now they're drafting people in Grand Cane. Grand Cane, they're drafting all the boys, right? So because he is underage, she has to sign for him. So just think about that for a moment. He's underage. That's her firstborn. She's sending him off to Vietnam. And for the young people, this was back in the day where there were not computers. There were not emails. My grandmother's phone was the phone that didn't have the dials. And I know young people don't know about rotaries. So it didn't have the rotary, didn't have the touch tones, none of that. You picked up the phone. When you pick up the phone, the operator answers and you give them who you want to reach. That's where that song comes from, Beechwood 45789. So people had 4 numbers. That was their number. Television. All of this thing where you're getting news 24/7 or people are, programming 24/7. You have hundreds of channels. They had 3 channels, ABC, NBC, and CBS. NBC, you really couldn't count that as a channel because the weather had to be perfect. No breeze. Otherwise, it's not going to show well. Television, when you were lucky, how the television was ending and there would be no programming? They play the national anthem. And then you just see the flag flying. That was it. So she signs for my uncle to go off to the Vietnam War. And let's be honest, geography in America is not our strongest suit, right? Nobody knew where Vietnam was. The only thing people knew is that people were going to Vietnam and people were dying. So she sends him off. They tell her, if you want to reach him, you send a letter and you just put his name on there and you put his number and you put Vietnam on it and hopefully it will find him. And for those who've been in the military, because I'm from a military family, usually a sergeant or whoever it is, when you're going off to training or they're sending you somewhere, they tell everybody, write your parent a letter. And you write it and it comes back to you. So my grandmother ended up getting that letter like 6 months to 9 months later. So when she's sending a letter to him, she doesn't know if he's arrived in Vietnam. She doesn't know what's going on in Vietnam. She's just able to see certain things that are happening on television. And I tell that story to everybody here to let you know your country no longer has a draft. So unless something changes, that's not there. So your being here for jury duty, that's an inconvenience. My grandmother and other people who are sending their sons or sent their sons and daughters off to war, that's a sacrifice. So I realize that sometimes people don't want to be here for jury duty, but guess what? We cannot have a jury trial without jurors. We cannot have a strong legal system without juries. Next story I'm going to tell you. Everybody in law school, some people decided to practice criminal law. Some people decided to practice civil. I've always loved criminal law. It's always been my passion. My friend decided that she was going to do civil law. No offense to the civil attorneys, but usually people who practice criminal law are in court every single day. And they're trying more cases than they try on the civil side. So she gets called up for jury duty. So she calls me, she tells me. And I said, great. She's like, let's do lunch. I'm like, yeah, let's do lunch. So we have lunch. I ask her, how is jury selection going? She tells me it's going fabulous. It's going great. Now that I'm a judge, I'm thinking, how could it be great or fabulous when you were not with me? But okay. So she tells me that. And I say, what do you mean by that? She says, it's like when we were in law school. I'm on the back row. I'm keeping my head down. I'm not saying much. So she's like, so I'm not going to be selected. I laughed hysterically. And she says, what's so funny? I said, well, it's funny, but I'm happy. She's like, why? I said, because we're going to get to have lunch all week. So other than raising a card saying, please select me for this jury, the best way to be on this jury is to say nothing. And I tell people that story, which is a true story, because both the state and the defense have a limited time to speak with you. And they're trying to get to know you and get to determine whether or not you perhaps will be a great juror for this trial. So please speak to them, be talkative, and remember what I said about whether you can be fair or not. Everybody has things that have happened to them in their past. Fairness means whether or not, if you're selected on this jury, can you listen to the evidence that's presented to you and make a decision, if you can, and make that decision based upon the evidence that you hear in the courtroom. Does everyone understand?
Yes.
All right. Does anyone need a break? All right. So this is what we're going to do. One, you're going to leave your cards behind. Number two, I'm going to give you a break. We're going to come back here at 11:20. So here's the thing. Everybody has to leave. If you need to take a restroom break, because sometimes there's a crowd at the restrooms, wherever you see a stairwell, whether you go upstairs or downstairs, there's a restroom on either side. All right, with that being said, look to your left, look to your right. That is your jury buddy. Make sure that you all are outside, lined up at 11:20 and in this same order that you came in. And so everyone has to leave. And if you want to leave your personal items, you can. No one will bother them. All right, everyone, please rise for the jury.
Yeah.
I would love one at 5 minute stretch.
Vince? You want a time announcement? I'm doing the first 10 minutes on that, Lorraine.
That would be a question. for
Lorraine,
Rainey.
you want a time announcement?
I would like a time announcement. What are y'all gonna do?
Brittany?
I said 5 minutes.
5? Yeah,
Okay.
5 or
Ready, Judge?
5 or 10?
Yes, and you all don't have to, question number 28. Deputy Laura told me he hasn't been able to understand, so there's no need to question it.
Okay.
Yeah.
All right, let's bring the jurors in.
All right.
So I took notes of both of those things.
You guys for the jury?
I'm gonna put this down here so no one can see it.
Should be easy. You guys know where to fit.
Citizenship.
No, why would I do that?
Well, one man said he's only here a year.
I'm not asking that question.
I am.
Looking for me. Can I move over?
Do I see the state of defense briefly, please?
Yes. Oh, yeah. Oh.
All right, everyone, please be seated.
State, you may proceed.
Thank you, Your Honor. Good. Almost afternoon, still technically morning. Okay. As I said, my name is Brittany Mitchell. I am with the DA's office along with Alexander Jackson. Marissa Giovenco is here. She's a special prosecutor on the case. She's not necessarily with the office. She came to sit on this case. I like to start off with this picture, mainly because I like to stress that that is not accurate. In Law and Order, you have cases that pop up and they have all these like special investigators on it, and then they go to trial like the next day. And everything's polished and goes according to plan for the most part. The reality is more like this. I'm sure as y'all have been sitting here, you've seen me on my phone and it's all work related stuff. But we are coordinating witnesses. We are anticipating what's going to happen over the next few days. And I apologize in advance for being on my phone. I promise it is for work purposes. What it takes to be a juror. Okay, this might show like the generational divide in this group. Who knows what the picture is on the lower right? Juror number 26. Can you stand up? What is it?
So it was a show based off of everyone else not, or being in on the fact that he wasn't really a jury, and they were trying to see how he hurt this person. So they had all these crazy things happen and to see how he reacted. He ended up getting money for people.
He was good. You just gave away the ending for everybody. You can sit down. Yeah, it's a series. I highly recommend watching it. It's hilarious. It's called Jury Duty. It is not anything related to what jury duty is actually going to be. This poor guy had no idea. Everyone around him was an actor. So it's crazy. It's loony. I can almost assure you that the stuff you saw there is not anything you would see in court. Okay. Now, what about the top left? Who knows that one? Juror number 22.
12 Angry Men.
12 Angry Men. And juror number 22, what was 12 Angry Men?
Was it?
Yeah.
A bunch of guys all went in a room. I believe everyone, I don't remember which ones thought he was guilty or not guilty, but 11 guys thought he was one way and one guy didn't. And then so they were all pissed off at him, and then he ended up turning everybody around.
Okay, yeah, it's kind of like the quintessential jury duty movie. A lot of jurors talk about it. It kind of shows the power of being on a jury, because you will get to know your jurors, and you will learn how to give your input and make a decision as a group. The ground rules for jury selection: tell the truth. That's the only oath you've taken so far, is that you tell the truth. Understand, I call it the splash zone. Anyone here who has not been to SeaWorld? There's usually one or two. Juror number 4. Juror number 25, juror number 15, it's fine. There is, at SeaWorld, there is a splash zone. The first, I don't know what, 4 rows or a special color to let you know that if you sit here, you might get splashed. So generally, I would say if you're in the first 30, 35, I consider that the splash zone. And like the judge said, if you want to make sure that if you feel like you are not a good juror for this case, you need to speak up. Because if you don't speak up, especially those of y'all in the splash zone, you will almost assuredly get on the jury. Okay? This quote here, I pulled from the Texas Office of Court Administration. Jury service is a privilege that offers the average citizen an unequaled opportunity to influence and deliberate over fundamental matters of justice. As a juror, you are in a position of responsibility. You will need to be fair, impartial, and be willing to make decisions that are not based on your personal feelings and biases. Basically, what that means is that as a juror, you will listen to the evidence, you will listen to the law, and you will apply the evidence to the law. All right, who is this? Willie Nelson. Okay, so one thing, I think the judge covered it. Just because you're not, well, I'm jumping ahead. Not every case is right for every person to be on, okay? So if I was prosecuting a marijuana case, do you think Willie Nelson is capable of being fair and impartial as to marijuana? No. So even though I love Willie, you know, I think he's a good Texas icon, right in the Lotus, I would not want him on my jury in marijuana. Now, for a case like this, sure. For burglary, sure. Marijuana specifically might not be the best case for him. And that's fine. That is fine. We just need to know that. Beyond a reasonable doubt, this is the burden we have in a criminal case. It is beyond a reasonable doubt. It is not beyond all doubt. If it was beyond all doubt, then you would have had to be there yourself. There is always some kind of doubt, but is it reasonable? It is beyond a reasonable doubt. This is an example. Prosecutors give it all the time. I give it all the time. Let's say you are going to a movie. What's one of the movies that are out right now? Is there a good one out right now? Kung Fu Panda 4, okay. Who here is planning to see Kung Fu Panda 4? Yeah, I think it should. Okay, let's say you're taking your kids to Kung Fu Panda 4, you're driving up, you see, it's a basically nice day, but there's some clouds coming in. And it starts to get dark, and you go in, you watch your movie, and then you come out, and you see that. You see a rainbow, and you see everything is wet. Is it possible that the fire department came and sprayed water everywhere and sprayed it in the air, which made a rainbow? Is that reasonable given the situation? There you go. Similarly, we have a puzzle piece. We have a puzzle. It's missing a few pieces, but I believe a reasonable person could say it's still a picture of the earth, even though it's missing little pieces. Now here, we are here for serious cases. These are crimes against children. We have injury to a child. We have two different types of injury to child. We have injury to child causing bodily injury. And we have injury to child causing serious bodily injury. And then we also have an aggravated assault with a deadly weapon. Injury to a child. They're two different offenses, but they're basically the same elements with different injury required. So that the defendant, Jose Ruiz, on or about a date in Bexar County, did intentionally or knowingly cause bodily injury or cause serious bodily injury to a child, which is anyone 14 years of age or younger. Intentionally or knowingly is what we refer to as the mental state. Intentionally is pretty self-explanatory. If I go, come up to Marissa and just go like that on the head, I am intentionally hitting Marissa. I am intentionally trying to make an injury on her, right? Now, knowingly is when he is aware that the conduct is reasonably certain to cause the result. So if I'm standing next to Marissa and I'm just like, bam, I'm not looking at her, but I know she's there. And I know that my conduct will probably result in her getting injured, right? Is everyone with me? Yes. Okay. Now, injury, I told you there's two types of injury that this jury will hear about. There is bodily injury. This is the injury typically would be in like a misdemeanor case if it was an adult. Bodily injury, physical pain, literally just pain. Pulling hair can be physical pain. Elbowing someone in the stomach, physical pain is bodily injury. Also illness or any impairment of physical condition. There's no requirement that the injury be visible. Doesn't have to be bruises, doesn't have to be bumps. All that someone has to say is that, yes, they pulled my hair and it hurt me. In our case, a child. Now, serious bodily injury, I'm going to spend a little more time on. Serious bodily injury can be shown in three ways. Number one, there is a substantial risk of death or death that results. There is serious permanent disfigurement that results, or there is a protracted loss or impairment of the function of any bodily member or organ. That's a mouthful, so I'm going to break it down a little bit. Does anybody know what this picture is? Any sports people? Somebody? It's of a football game. So I'm not a sports person. I literally just Googled pictures of someone getting punched, and this came up. Apparently in 2010, this was a big deal. Johnson pummeled Finnegan on the Texas or Tennessee Titans. But if you have, let's say, an 18-year-old high school football player, okay, and they're on the field, obviously they get spirited, and he comes up to a freshman 14-year-old football player, and he gets on him and pummels him, okay, and he causes a brain injury, which that's a lot of force to do that. Now, they'll get medical help. You know, subdural hematomas happen a lot and people can heal from it. However, it's important that the substantial risk of death or death that occurs from the injury, you look at the time it was inflicted. So prior to medical treatment. So someone might get, let's say, a bad head injury, or they might get, you know, a big old laceration in their stomach that creates a substantial risk of death, and they might heal from it. It doesn't mean that it wasn't serious bodily injury. Understand that? Now I'm going to move to, let's say, which one are you? Oh, I'm sorry. Let's see, I think you are doctor. Juror number 10, right? Okay. What kind of physician are you?
I'm an eye surgeon.
You're an eye surgeon, okay. Are there any, could someone potentially, it's hard for an eye, I don't know much about the eye, but is there, I know the eye is pretty close to the brain, right? So would there potentially be a situation where someone maybe got an eye injury where it could potentially be a risk for death? I actually don't know the answer to that.
Sort of, yes.
Sort of, yes. Okay. Not a good example. Now, let's talk about the head injury that I said. Okay. What kind of thing would you expect to see from that? Anyone? For number 3? A head injury.
Well, sometimes you don't see anything at all.
Sometimes you don't see anything.
Sometimes you can see big lash.
Right. So sometimes, depending on the nature of the impact, you might see like a bloody nose or bloody eye or something like that. But if it's internal, you may not see it, right? If your brain is injured, you may not see it. So there may be injuries inside your body that may not otherwise be visible, but it can still lead to a substantial risk of death. Does everyone understand? Everyone agree? Permanent disfigurement. Okay, somebody's got to know what this is. Okay, raise your card, somebody. Juror number 27.
It's Mike Tyson biting the ear off of, I don't remember the other boxer. It's Mike Tyson biting the ear off of a boxer. I
Yeah,
don't remember the boxer, but I remember watching.
Evander Holyfield.
Yes.
Yes. And what happened when he bit the ear off? Or, what happened when he bit him? Right? He bit a big chunk of his ear off. Answered my own question. Does the ear grow back?
No.
No. So there's a pretty good argument to say that that would be permanent disfigurement, right? Okay. He's not going to die from it, right? But it may be like that for the rest of his life. Everyone understand that? Okay. Protracted loss or impairment of a bodily member or organ. That is a lot of words. Can anybody know what that means? Read it and they're like, oh, I get that.
A broken leg or you have kidney damage.
Okay, that's a good example. Juror number 20. So a broken leg or kidney damage, right? What happens if you have kidney damage? It can kill you eventually, right? So do you think that could be under multiple parts of the SBI? The serious bodily injury, sorry.
Oh.
Because there's substantial risk of death.
Yeah, and then the protracted loss of your organ kidney.
Okay, so protracted loss means you can't use it like you normally do. That's basically what all those words mean. There's an injury to something on your body, and it does not function the way it's supposed to for a protracted or a long period of time, longer than normal. So I have an example of a broken foot, right? If your foot's broken, you can't really walk on it. So you have protracted loss of use of that foot. And then also, it's a broken jaw. If your jaw is broken, you probably can't chew your food, and it's going to take a long time to heal. Does everybody understand that? Okay. Manner and means. When we say, what is the manner and means of an injury? Does anybody know what I mean? That's literally the answer is right there. Jury number 12.
How did it happen?
How did it happen? What caused that injury? How did we get to the injury? How did we get to the serious bodily injury? Well, what if we don't know? What are some circumstances that might come about where you don't know? Anyone? I'm going to call on the slash zone people. Jury number 14? There's no physical signs, maybe. And what about with the child? We're talking about a child, right? Jury number 26?
The child could be not able to speak or have reasons to not be able to communicate verbally.
Right. They may not be able to speak. There may not be any communication from the child. Anyone else? Any ideas? Jury number 22?
Child may be afraid to speak.
The child may be afraid to speak. You know, how did you get that head injury? And they don't say, right? But you know by the nature of it that it's not something they did themselves, right? And who controls that information? Who besides the child who can't speak would know what happened?
The aggressors.
Jury number 27, the aggressor, right? Anyone else? So manner and means unknown. That's what we're talking about. Is there anyone here that would be unable to return a verdict of guilty if the state proved to you beyond a reasonable doubt all of those elements we talked about of serious bodily injury of the complainant, but we could not show you specifically how the defendant did it? Is there anyone here that says, I understand the law says we don't have to say how, because sometimes we can't. I understand we don't have to say how, but in order to find someone guilty, even though I believe the elements beyond a reasonable doubt, I need to know exactly what happened. Juror number 14, juror number 12, juror number 33, juror number 37, juror number 5, 17. I'm sorry, can you put your cards back up again? Okay, I'm gonna try to go in numerical order. 1, 2, 5, 7, 12, 13, 14, 17, 22, 33, 37, 39, 40, 42, 46, 48, 53, 59, 66, 69, and 71. Okay. And to make it more complicated, I think I've got y'all so far, right? Anyone here lost? Okay. I'll speak now. In addition to actually committing the offense, there is another way that the law says that someone can be guilty of injury to a child causing serious bodily injury. So we have the commission. They actually did the action that led to the injury. There is something we call omission. And it's something for children, elderly, disabled individuals. There is either a legal duty to act. You are the guardian, and you know that this child is being abused, or you know this child needs medical care, and you don't do it. And then it leads to serious bodily injury, substantial risk of death, permanent disfigurement. If you have a legal duty to do something and you do not do it, and the child suffers serious bodily injury, you are just as guilty as if you did it yourself. Does everyone understand that concept?
Yes.
Is there anyone who doesn't agree with that? Who says, I don't think I should be responsible? Okay. Now, the other thing is someone who has assumed care, custody, and control of the child. It's different than legal duty. Legal duty is like a guardian. You are legally obligated to do something. Someone who has assumed care, custody, and control of the child isn't necessarily a guardian. It is determined by their actions. Maybe they take a child in, under their wing, take a child on vacation. By their words, they say, I'm taking care of this child. Or course of conduct, which is basically a way of saying you look at everything together. Their words, their actions, how often they have the child, all of these different factors. Somebody, maybe a family friend, can have care, custody, and control. Additionally, it is to the extent that a reasonable person would conclude that the actor has accepted, they have accepted their responsibility of that child for protection, food, shelter, or medical care. It does not mean that they're the exclusive providers, okay? Can anyone think of an example where there may be more than one person who has custody of care of a child in a household? Anyone? Juror number 18?
Like if perhaps the grandparents live there and the parents went out, so the grandparents are watching the child.
Okay. Right. The grandparents have assumed care, custody, and control. What about just in general, the grandparents live there, right? And they see something horrible happen and they don't do anything. What about someone that's not family? Who might also have assumed care, custody, control of a child? Juror number 3?
Maybe a sitter, somebody that takes care of children.
A sitter, right? Juror number 7? A friend who always watches them. A friend who gives them food, who has taken them to the doctor. Okay? I know it's kind of complicated, but you know it when you see it. Someone that the child relies on. The important thing is that it is their actions. It is them taking the child. It is them doing medical care for the child. It is them maybe disciplining or providing food. It is their actions that dictate whether they have assumed care, custody, and control of the child. And that a reasonable person would believe that. Otherwise, everyone would say what, right? It's not my kid, right? Does everyone agree with that? Okay, now, is there anyone here who doesn't agree with that? Who thinks it should only be a legal guardian that is responsible legally? How might someone show that they have assumed care, custody, control of the child? We kind of just talked about that. What kind of relationship do you expect with the child? For someone like that. Juror number 14? A close relationship. Does that mean they like each other? No. Okay. Juror number 4 says no. Did anybody here have a caretaker who wasn't a family member that you did not like growing up? Juror number 4. You got you. And how might a non-family member show their actions? Through their actions, show that they are stepping into the role of a caretaker for a child. Juror number 7.
Administering authority. Child telling something not so.
Administering authority. right? These are my rules. Everyone, does anyone feel that that's not a good grounds? And how would you expect a child to act around someone who, let's say, juror number 7, who's administering authority? Anyone splash them? Juror number 4.
I mean, I would expect the child, I mean, depending on, if the parents or whoever the guardians to say, go with your uncle or aunt. Do what they say, they're the adult, that kind of a relationship.
Okay, juror number 14. Safe and secure. Loved. What if they don't like them? Scared. Juror number 6. What might a child call somebody who's taken on that caretaker role? What are some names they might say?
Dad, Chelsea, people like that.
Yeah, mom. They might call him mom. They might call him dad. Some kind of nickname. Did anyone have somebody like that growing up? They weren't really family, but you called them a family name? Yeah. All right. I think we've covered injury to a child. Hopefully y'all followed me. I know it was a little complicated, but basically, if you have a responsibility to a child, you have a responsibility to a child. You don't get to choose when and where and how. So I'm going to move on to aggravated assault with a deadly weapon. The defendant, on or about a date in Bexar County, Texas, intentionally, knowingly, or recklessly. So this adds a new mental state, reckless. The last one was intentionally or knowingly. This one also includes reckless, and it causes bodily injury. And while causing that bodily injury, there is a deadly weapon used. Okay. So recklessly, I talked about, either intentionally or knowingly hitting Marissa. If I just am like going around the room going like this, and I hit her in the head, I would refer to that as reckless. I was being reckless, and that's what led to the injury. So aware of, but I consciously disregarded that there was a substantial and unjustifiable risk that result would occur. Okay. Now, deadly weapon. This can be a little tricky for some people. It's anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. And when I say anything, I mean anything. So you can see in the back of that picture, there's a car, right? Cars are not necessarily meant to hurt people. That's not why they're made, right? But can they be used as a weapon?
Yes.
Yes, they can cause serious bodily injury. They can cause death. What about an ice pick? Right? What about a rock? A rock, right? What about what other items that you may not traditionally think of? Who said hands? Oh, juror number 80. Are you 80? Yes. Yes. Juror number 80. All the way in the back. I'm glad you can hear me.
We also said hands feet.
Oh, you do martial arts. Okay, so anything you can use when I say anything, right? You can use your hands, you can use your feet, you can use your knee, you can use your forearm, elbow, anything, because it's how it's used. That's what makes it a deadly weapon. Does everyone understand that? Okay. Reasonable discipline. So when you are involving an injury to a child, one of the defenses can be that it was just reasonable discipline. It was discipline. Well, the law has a standard for that. It says that you are allowed to use force under a child that is 18 years of age, but it must be someone who is the parent or step parent or acting with consent of the guardian, so a caretaker. And it can only be to the degree the actor reasonably believes the force is necessary to discipline the child. to safeguard his or her welfare. Okay, so you can spank the butt. You can, it leaves it open to parents being able to parent the way they want, as long as it is reasonable. As long as it doesn't use deadly force. And it's reasonably necessary. Corporal punishment. Who here was spanked as a kid? Okay, who here was not spanked as a kid? Let's see. Sorry, can you turn your number? Juror number 23, 55, 75. Oh, 60, 61.
Wait, I missed those numbers.
Sorry, put them up again. Who here was spanked as a child? Or, no, I'm sorry. Who here was not spanked as a child? Yeah. So we have, I think I lost one.
23.
23. There we go. 23, 55, 60, 65, 73, 75. 31. All right. So who here, and this might be controversial, and I promise it's no judgment, but who here still spanks? You spank your children. Okay. So we have 1, 23, 24, 63, 68.
They're all drunk now, but I spank.
69, 71, 72, and 80. And she does martial arts. All right. Where is the line? Now we talked about what's reasonable, right? And this might be different for everybody. Where is the line? Like when does spanking your child become not okay? Right? Juror number 14? If it's out of anger, okay. Juror number 4?
Well, I mean, some parenting models don't use corporal punishment at all, that they just say.
So some people are
Okay.
like absolutely none at all. Is there, I guess, raise your cards if you think any physical discipline is too much. Okay, juror number 4, 7, 12, 15, 18, 20, 22, 36, 37, 39, 45, 46, 53, 55, 58, 65, 66, 73, 74, 22, and 4, if I didn't say it. Okay. Has anyone here ever argued with family or friends about the way either you're disciplining or they're disciplining their child? Raise your cards. Jurors 1, 9, 10, 11, 12, 14, 15, 18, 19, 20, 21, 22, 23, 24, 31, 33, 34, 35, 37. You can put your card down, Ruiz, your number. 44, 45, 46, 53, 54, 58, 60, 61, 70, 75. Of those that just had your card raised, who here was arguing because you felt the child was being punished too much? Okay. 9, 12, 14, 15, 18, 20, 22, 23, 24, 31, 35, 34, 35, 37, 45, 44, 46, 58, 60, 61, 53, 54, sorry, 60, 70, 75. All right. Does anyone here, and I actually know people that this is true, so there's, again, no judgment. Does anyone here have a scar from when you were a kid from discipline? It happens. Juror number 20, juror number 53, 31, 70. What are reasons that someone would abuse a child? Juror number I'm sorry?
Project anger.
Anger.
Anger themselves.
Juror number 80, angry, they are angry people themselves.
They project that anger.
And they are projecting it onto a child. Okay, thank you. Oh, I was supposed to tell you to stand up, sorry. Juror number 18,
I was adopted, and so my mother would beat me because she wanted my dad to see that I was lesser than her natural children.
right,
What's that again?
I was adopted, so my mother wanted to beat me to show my father that I was far less than the natural children she gave birth to, because he would stay with her if the natural children grew up whole, but the adopted kids were nothing, because he could still divorce her, she felt. So it was a power problem, a power, so it's,
did it
No,
make you?
sorry.
It was a power thing.
yes,
It put you down to give him power, or give your mom power.
correct,
Okay. So it might be their own personal motivations, right?
yes.
Someone over here had their card raised? Maybe, number 9?
No.
No. Juror number 69? I'm sorry? Mental illness, yeah, for sure. Juror number 75?
They think that the abuse is going to make that child a more compliant child.
They want them more compliant, okay? Juror number 67?
Repetition of whatever that child is doing, not listening.
Okay, maybe the child just isn't listening, so it goes to abuse.
Will you raise your numbers?
Yeah.
Sarah? Sorry.
Juror number 65?
Alcohol or drugs.
Alcohol or drugs might make it worse, right? Juror number 53?
Domestic violence between the relationship with the father.
Okay, so there's maybe a domestic violent relationship between the two, the mom and significant other, and they take their anger out on the child. Juror number 14?
Resentment for having getting pregnant by someone they didn't.
Right, resentment. Maybe they just have something against the child, right?
No, it's the actual parent.
Oh, against the actual parent. Juror number 62? There may be emotional scars, right? Juror number 67?
I do want to add on to it, a lot of times, as adults, a lot of children have special needs and we don't know that, because these children are not, tested. So what, as I grew up in old school, being disciplined, a lot of these children don't understand the discipline and why you're spanking them, or why you're getting after them, so they repeat themselves. So that's part of what I meant also.
Right.
Because I have a son that, a stepson that is autistic.
Okay,
So
absolutely.
I learned that.
Right. People that don't know and it's just too much, right? Juror number 70?
The abuser was abused themselves, so they're repeating the cycle.
Repeating the cycle, right? It's normal to them. Someone else?
I was gonna say it was
Juror number 8.
generational.
Generational abuse, right? Juror number 41. Haven't heard from you.
User might get pleasure out of doing it.
Maybe they get some kind of pleasure, right? Juror number
5
8
minutes.
is nodding your head. Yeah. Juror number 32?
There's a difference between discipline and abuse.
Right.
What number? I'm sorry. What's your number, ma'am? I'm sorry. 32.
Sorry, 32. Do most kids who are being abused tell right away? People are shaking their head no. Anybody have think of a reason why? Juror number 14?
They're afraid of retribution from the partner that actually abused them.
Okay. Juror number 21?
Shame.
Shame. Juror number 7?
They don't know it's wrong.
They don't know it's wrong. It's what they've known their whole life, right? 33?
Sometimes they're afraid because they think it's gonna happen again.
Right, they're just scared. 53?
Retaliation.
Retaliation. 64?
Sometimes they don't want their parents or their husband to get in trouble.
Right, they still love their parents, right? Because they don't, it kind of goes to they don't know any better. Juror number 69? Okay, no one's gonna believe them. Juror number 63?
They're afraid that CPS will take.
CPS. They're scared of CPS. They don't want to be taken away. Juror number 71?
They're afraid to lose their electronic devices and all that kind of stuff.
Yeah, they don't want to lose, you know, the stuff they have. They don't want to lose their stuff. They're number 80.
It's their lens of their world, called phenomenology. You know, it's what they experience every day. And them, until they're able to use their cognitive skills, it's great, it's all they know.
Thank you.
We can add that.
Yeah, thank you. They're number 11.
They're told not to, or it'll be worse.
They're threatened, right? Okay, so you will have to judge the credibility of witnesses. I only have a few minutes left, so I'm just gonna say, it's really using your common sense. You know, you'll see people on the stand, you can read their body language, you know, listen to how they're talking. Listen for corroborating or evidence that supports what they're saying. There's different ways that you can judge that. You're not CSI. I saw an episode where they got like a fingerprint off of a breast, like that doesn't happen. But what evidence do you expect to see in a case like this? Oh, he's getting his card. Juror number 33?
What evidence do we expect to see?
Yes.
I guess actual full evidence showing if it actually did happen or not.
Yes, evidence showing it happened. Juror number 5?
X-rays.
X-rays, maybe? Ultrasounds, medical, some kind of pictures. Juror number 22?
Say photographs.
Photographs. Juror number 71?
Let's say pictures, text messages, and medical records.
Yeah, pictures, text messages, medical records. 23? Testimony, right. What is testimony? Someone? Well, I'm not sure exactly what I may have said. So testimony is just what people are saying. So what people say, you know, my name is Brittany. If I'm on the stand and I'm under oath, that is evidence. She said her name's Brittany, so you can consider that, okay? Physical evidence, medical evidence, forensic evidence, circumstantial, who, when, where, how, what circumstances around it go to support that, right? And then when you go back there, you'll put it all together. Bill of Rights, just to remind, there are constitutional protections. There is an absolute right to remain silent. Is anyone going to hold it against the defendant for remaining silent during this trial? All right, briefly punishment. I know I'm down to the wire, Judge.
Yes, you have 24 seconds.
Oh my goodness. Okay, so first degree, that serious bodily injury is a first degree. We talked about the hypothetical of an 18-year-old senior in high school pummels a 14-year-old senior in high school. So, but then we also have, you know, maybe someone purposely, you know, slices a child somewhere and it kills them, right?
Time. All right. All right, does anyone need a break? All right, defense, I'm sorry, someone needs a break? All right, defense, you may proceed.
I apologize because I am handicapped. I have to sit a lot. I want to get that out of the way, all right, because this is a trial. It's an ugly trial. Does anybody know about this trial? Anybody have any foreknowledge of this particular trial?
Number 49.
Number 49. Number 50. What do you know about this?
I'm sorry, Your Honor.
Excuse me.
Can we approach?
No, no need to approach. Who are the people who say that they have information about this trial? Could you raise your card, please? All right, 49, 50, and 80. All right. So ladies and gentlemen, what may end up happening with you three, we may call you up later to ask you about that. Defense, you can continue.
How many people have seen motions or information about this trial, pre-trial on YouTube? Nobody's seeing YouTube, nobody knows anything about this, what's going on. How many people are citizens of the United States?
What was the question?
How many people are citizens of the United States? Who's not a citizen?
Your Honor, I'm gonna object to relevance.
No,
You're not a
she can
citizen, you
ask,
can't be on the
excuse
jury.
me. One at a time.
How many people?
Is there
are not-
anyone here who is not a citizen? That's the question she's asking. Thank you.
Everybody's a citizen. Yes? Somebody mentioned that they were only in the country for a year. They have only been in American for a year. Hasn't been in the country for up to a year. Is that, did somebody say that? We have some language problems here. Are people not a citizen? Anybody at all? Okay, thank you. We're talking about parents, but what about the hookup culture? What about somebody who's not a parent, they're part of a hookup culture? Do you know what that is?
Can you repeat that?
We're talking about the defendant in this case, who's not a parent.
Excuse me, ladies and gentlemen, just one moment. Neither party is allowed to speak to you about what they think the facts are in this case. Does everyone understand?
Yes.
Parties are only allowed to speak in hypotheticals. Does everyone understand?
Yes.
So no, neither the state nor the defense can tell you what they think the facts are in this case. Does everyone understand?
Yes.
All right, defense, you may continue.
So if you know about, we want people that don't know about the case at all, that are just finding out for the first time. Has anybody seen anything about this case on television?
Oh, there's some more
Okay,
numbers.
can you raise your hands highly so we can see the number, please?
You know about this case because you heard about it on television.
24, 38, 49, 50, and 80. And once again, once we call the number, you can go ahead and pull it down. We just want to know who is indicating yes.
Right. And anybody in this audience, jury panel? I say audience because we're all on TV, we're all on YouTube.
All right, ladies and gentlemen, I'm going to give us a pause for a moment, and I'm going to have you all step outside, and then I'll bring you back in. So I'm going to give you a break here, and I'm going to give you a break till 12:30. But before you leave, I want the record to be corrected. None of you are on television. Does everyone understand?
Yeah.
Yes.
All right. Everyone, if you all please step outside. think I'm gonna have them do some eye drops.
I was trying this again.
Somebody told me they think it's old or something. I never had allergies until I came to Texas. Apologize to my because he had allergies. I'm like, it's not that bad. But now I'm like, it is that bad.
Huh? Yeah. I took the elevator. I took the elevator this time.
Myra's helping Jordan.
Right.
Myra.
Nothing going on.
Oh, no.
Oh, please be seated. We stand for you all. All right, defense, you may continue.
Thank you, Your Honor. Good morning, everyone. I'm Lorraine Efron. I'm one of Jose's attorneys. I want to talk about the phone thing. I'm so glad you mentioned it. If we're on our phone, it's this case related. So please forgive us if you see us on our phone, because otherwise, no cell phones allowed. Also, we have a lot of people in here right now, and some of the attorneys are sitting in different places, like where we're seated, or the placement has no particular significance. We're just trying to accommodate a large panel in a relatively small courtroom. So there's 3 attorneys on each side, and it's going to get cramped, and we're going to do our best. There's some places where we sit where the obstruction's viewed, the view is obstructed a little bit, so we're going to do our best. So there's so much to cover here. Let's talk about cases involving children, okay? Cases involving children. Who here, just based on the fact that a case involves an injury to a child, just based on that fact alone, says, I cannot act as a juror on a case involving injury to a child? Who says I cannot act as a juror in those cases? Now I'm going to go slow to read numbers, okay? 1, 2, 4, 9, 11, 12, 13, 14, 15, 16, 17, 18, 20, 22, 26, 27, 35, 36, 37, 38, and then 39, 42, 43. Yes, sir. I'll be right with you. Yes, sir.
I don't have a child.
Okay.
I never had a child, so it's a little odd for me.
Okay, number 30, you have no children. Okay, thank you, sir. Okay, 44, 45, 46, 48, 49. Oh, wait, 58. Did I say 48?
Yes.
53. 60, 61, 64, 62. I'm sorry, I'm a little 66, 69, and 80. Okay, so what we want to do here is impanel fair and impartial jurors for this kind of case. And there may be some things you don't want to discuss in front of everybody else. And if there's something that I ask you and you want to discuss privately in front of the judge, we will absolutely accommodate you. Okay? So we're not trying to pry. We're not trying to make your life, we're not trying to pry. But we just need to know, because everyone, one of the great rights of the United States of America is a right to be tried by a jury of your peers, a fair and impartial jury, right? Okay, so we have a lot of people who responded. I can't sit on a case involving an injury to a child. That already in itself means I cannot be fair and impartial. The people who raise their hands, would you agree that you cannot be fair and impartial on a case involving injury to a child?
Yes.
That's okay. Is there anyone who says?
Just one moment,
Yeah.
counsel. Let me pause you for a moment. Everyone, the question is whether or not, if you were selected on a trial, would you be able to listen to the evidence and base your opinion, if you can come to a conclusion, on whether somebody's guilty or not guilty based upon what you hear? So for those who raised your hand, who said that you have an issue with child cases, that's the question about fairness, whether you can sit on a jury, listen to the evidence, and base your decision, if you're able to come to a decision based upon what you hear in the courtroom. That's the question. So if there's anyone who cannot do that from the last people who raised your card, you may do so now. Raise your card.
We can or cannot.
Cannot.
Okay. Jurors who are raising their card cannot be fair and impartial on a case involving an injury to a child. I'm going to read numbers again, but okay. 1, 2, 4, 6, 9, 12, 13, 14, 16, 17, 18, 22, 26, 27, 64, 62, 66. Oh gosh, I'm so sorry, I'm out of order here. Okay. 38, 37, 35. I'm trying to get back on track. 39, 45, 46, 48, 49, 53, 60, 61, and 80.
And 62.
And 62. I'm sorry. I don't mean to overlook anybody, and I hate using numbers. That's the only way we can get it done. I wish I could remember your names, but under the best of circumstances, people I've met multiple times, I still sometimes can't remember names, so forgive me. I hate using the numbers, but that's what. Okay. If we well, okay, I'm sorry. Let me go into the burden of proof and beyond a reasonable doubt. Gonna switch gears just a little bit. Okay, there's multiple levels of proof in trials. You've heard us talk about them. Reasonable suspicion is the lowest, and then you have probable cause and preponderance of the evidence. It's tip the scales, 49-51. That's what you have in civil cases. Then you have clear and convincing, which means if the government wants to come and take your child, they can't just do it on 49-51, right? If somebody wants to terminate parental rights, the evidence that must be proven to terminate parental rights is what we call clear and convincing evidence. And we all agree that terminating parental rights is a big deal, right? We all agree, right? And to do that, the level of proof is clear and convincing. Now, we're here on a criminal case, and the level of proof here is beyond a reasonable doubt. Beyond a reasonable doubt is the highest burden in the law. And can somebody answer, why do you think in a criminal case, the burden of proof is so high that it must be beyond a reasonable doubt? Why would that be? Anyone have an idea? Number 7.
It's about absolute proof against not
That's right. The state must absolutely prove guilt. That's right. Thank you. Anybody else? Think about what's at stake in a criminal case. Number 63. Innocent until proven guilty. Absolutely. And the judge talked about that. Number 12. What will the rest of his life look like based on punishment? Thank you. Anybody else? What's at stake in a criminal case that's not at stake in any other case? Freedom. Freedom. Who said that? Freedom.
What number was that? Yeah, what number was that?
What number are you, sir? 45. Thank you. What's at stake in a criminal case? Freedom. Freedom. What about a criminal conviction? It's also a big deal. Would you agree with that? I mean, obviously, freedom is the biggest, but there's much at stake here. And the state has vast resources available to it to bring an accusation against a citizen, right? The state makes accusations, but who is the ultimate trier of fact? Who makes the decision? Is it the lawyers, the judge, or the jury? Who makes the decision as to guilt or innocence? The jury, right? And so if you have 12 jurors impaneled here and sworn to act on the jury, you have 12 individuals, 12 independent judges of the facts. You don't become a 12-person unit. You become a group of individuals, right? And each individual juror must decide the facts for themselves independently. Does anyone have any questions about that? Who feels like once they have made a decision with regard to a case that they can stick to that decision? Does everybody feel like they can stick to their decision once they make it? Does everyone agree with that? I mean, the judge is going to give you a lot of instructions once a case goes to deliberation, and you'll get a bunch of instructions from the judge, and you'll have that to take back with you in the jury room. But we have 12 independent judges of the facts here. Y'all have heard of felonies, right? Right. And there's different kinds of felonies. There's something called a state jail felony, which is almost like a enhanced misdemeanor for minor drug cases. And it's kind of a new class of felony that was created many years ago. That's a state jail felony. And then you have third-degree felonies. The punishment range on third degree is 2 to 10. Then you have second-degree felonies, which are punishment range 2 to 20. And then you have first-degree felonies, which are a range of 5 to 99 or life. The jury in this case, well, we have to talk about punishment here. Whether or not we get to it, this is our only opportunity to speak to you about issues that impact your thoughts on punishment, right? So this is our only opportunity to talk. I guess I need to shut up and let you talk, right? So let's talk about punishment here. Who feels like if I believe an injury to a child occurred, if I believe the state has proven a person has committed an injury to a child beyond a reasonable doubt, if I believe it, I could never consider the lowest number of years on punishment. I could never consider the lower punishment. Number 1, number 2, number 3, number 4, number 6. These are people who could never consider the low end of punishment if you believe that the state proved it beyond a reasonable doubt that there was an injury caused to the child. Okay.
And everyone, when she says consider, that doesn't mean give it. That means consider the full range of punishment. You may continue.
Thank you, Your Honor.
I have a question.
Yes, ma'am. Let me get these numbers done, please. Thank you. Well, 11, 12, 13, 14, 16, 17, 18, 19, 20, 21, 22. We're good? Okay. 24, 25. Do you have a question?
Yes.
Okay.
Actually.
Number 25.
Because I know previously we talked about serious bodily injury and regular bodily injury. So what are you referring to?
I didn't actually distinguish.
What? I think it would count. Clarify.
Well, would you, because you're saying I might be able to give a low number if it was not serious, but if it was serious, I would have to give a high number?
No, not necessarily. Just wondering.
I didn't distinguish, I'm sorry. I didn't mean to make it confusing.
So, well, it does, because it's like a little bit like I'm not really sure which way I would go.
You don't have to tell us. You don't have.
Everyone, no party is allowed to pin you down and say, would you give this number or would you give that number? What defense is asking is whether or not you can consider the full range of punishment. You acknowledge that in some cases, the range of punishment is, and counsel, I've paused your time. You acknowledge that in some cases, probation. In some cases, it's 2 to 20. In some cases, it's 5 to 99 years or life. In some cases, it's 2 to 10. Does everyone understand?
Yes.
So that means you have to acknowledge that the law says if somebody's found guilty in some injury of child cases, the range of punishment could be probation. It could be 599 years or life. It could be probation and it could be 2 to 10. It could be probation and it could be 2 to 20. So you have to acknowledge that that is the range. And you have to be able to, if you were to find somebody guilty, you would have to be able to consider those full ranges and put whatever the facts are you think they are to consider what punishment someone would deserve if you're able to come up with the punishment. Does everyone understand?
Thank you.
All right, Ms. Efron, I'm sorry. You may continue.
I'm sorry. Okay, so I'm not sure what number we left at.
25.
25.
Can we just start from there?
Yeah.
Clarify it.
Okay. So forgive me, let me try to regroup here. The full, I'm asking you, can you consider the full range of punishment? That means, can you consider the low end? Or any number after that, but I'm asking, can you consider the full range of punishment? Or I think what I asked is, if I believed that there was an injury to a child,
Is it intentionally and knowingly causing?
I
injury to
didn't
the
put that
child?
in there. I didn't put that in there. But would that be important to you?
Yeah, absolutely.
Okay, why would that be important?
Well, I mean, it goes to the abuse,
It-
intentional abuse.
Well, and state of mind, right? Do you think, what are some things that could affect state of mind, say intentionally or knowingly? What are the kind of factors that you feel like could affect a person who you believe was committing abuse? Whether it's intentionally or knowingly, you believe that's important? Whether it was reckless, you believe that's important? What if a person themselves had been a victim of abuse? Is that something you would consider important when you're considering the range of punishment? If the person was themselves a victim of abuse, if they were a victim of abuse themselves, and you had just convicted them, with me so far? If they were a victim of abuse, and you have convicted them, would that impact, would that be a relevant factor for punishment? Who agrees it would be a relevant factor for punishment? We had someone had touched on it earlier about generational abuse or, having it, experience it in their family and carrying it on. Number 62, who thinks being a victim of abuse would be something you would consider as relevant when considering the range of punishment? Anybody here? No? Okay. Anybody, number 36? Number 23? 38? 55? 54? Yes, ma'am.
I feel like we didn't get captured on like the other question over.
I know, I'm sorry. Okay, go ahead, answer.
Yeah,
Answer.
no, it was more about what we consider the low range. We're still answering the question, like half of them captured and we weren't. So.
I know, I did appreciate that. Okay, so
Are you
let's,
saying it so? if
All
the
right, so
person-
everyone, remember, please, the court reporter. And so she has to take everything down. So if any of you are responding, just raise your card, wait for counsel to acknowledge you by number, and then you can respond. Otherwise, it's difficult for the court reporter to take it down. All right, you may proceed.
number 22.
Okay, well, I think what I'm getting at is you're asking if a person is convicted of abusing a child, but he or she may have been abused themselves, would I consider that a reason to maybe consider the lower end of this one? I think the answer is absolutely no.
Number 20.
Somebody's got to break the cycle.
Someone's got to break the cycle. Who agrees with number 22? Okay. Let me. Okay, number 22 said, I would not consider the fact that someone was abused in my punishment consideration because someone's got to break the cycle. I would not consider it. Number 1, number 2, number 3, number 4, number 6, number 7, 8, 9, 10, 11, 12, 13, 14, 16, 18, 19, 20, 21, 22, 24, 25, 26, 27, 29, 30, 31, 32, 33, 34, 35, 38, 37, with me? Okay, 39, 40, 41, 42, 43, 44, 45, 46, 48, 49, 50, 51, 53, 55, 56, 57, 58, 59, 60, 61, 65, 64, 63, 62, 66, 67, 68, 69, 70, 74, 75, 76, 78, 79, 80. Okay.
You missed 73.
I missed 73. I'm sorry about
And-
that.
5.
And 5.
And I missed number 5. I'm so sorry. Ma'am, what are some things hypothetically that you think might be important when considering a range of punishment?
The evidence, I would also have for medical records, be beyond the actual, situation that occurred. And I would go with X-rays, CAT scanning, and prior, if they have any other type of, complaints, other type of abuse in the past, as far as other, people with other prior bodily injury.
So you're saying that you would need proof that a person was a victim of abuse in order to be able to consider it?
No,
Okay,
no,
okay.
in order for me to decide on something.
Decide
that
whether,
would be the type of
okay, we're,
evidence that I would look at.
okay, in terms of whether I thought an injury occurred, I would want X-rays, medical records, those kinds of things.
And prior to that as well,
History,
right?
Right. okay. So we kind of switched gears just a little bit, but I appreciate that. So we're talking about what kind of proof would I need to show that an injury occurred? I would want medical records. I would want some physical proof, correct? Okay. Now, thank you, going back to punishment. If you wouldn't consider whether a person was a victim of abuse, what would be some things you might consider, hypothetically, what would be some things you would think about on punishment that might be important? For example, do you think the goal of punishment is revenge and retribution? Do you think the goal of punishment is rehabilitation? What are some things like that that occur to you that hypothetically you think might be important in deciding a punishment? Anybody have some thoughts on that? Who said that? Number 67? So you think number 63?
I would.
What are I'm sorry, sir, can you please?
I'm sorry, I apologize, 'cause I didn't stand here.
Mm-hmm.
I think what I would have to ask is whether other people that have been convicted of the same thing, been punished or sentenced in the past, there needs to be a consistency. It's not about revenge or retribution or anything like that. It's just, we have to play the law.
Anybody else? Number 10, what would you consider?
So the degree of bodily harm. So losing your pinky toe permanently would still be considered serious bodily harm because you lost a portion of your body. To me, that's different than somebody who ends up being paralyzed from the neck down.
Okay, fair. Yes, sir, number 4.
I guess I would be concerned about the motive and is this just cruelty or is this an accident? We don't know the details of.
Okay.
Whether, you know, like, did somebody beat the child? Did they cut the child? Or are they just being cruel or did they get in a car accident?
Okay,
They were drunk driving, you know what I mean?
right.
There's a
There could
lot-
be different circumstances that gave rise to the
Right.
injury that would affect how you think about punishment.
Yes.
Number 23, I'm not sure we have heard from you. Have we, give us your thought.
Perhaps the mental capacity of the accused.
Okay. All right. Number 32.
If the person is continuing danger.
Okay. Continuing danger, in other words, risk, you would consider risk or lack of risk as a factor in punishment. Okay. Anybody else here things hypothetically that you think might be important in a consideration for punishment? Number 5.
Yes, if the person has been convicted of other type of abuse
Okay. Prior convictions. Okay.
to bodily injury.
Okay. Anybody else? Did I see some other numbers here? Okay. Yes, ma'am.
Yeah, my question, I'd like to answer, please. In regards to a jury, in regards to any year of regardless of what the defendant thinks, feels, background, whatever. You have, when there's something egregious that happens to a child, it's it the jury that decides that this punishment up here is either severe enough and can ask the court to consider the death penalty.
Fair question. Okay. I'm not gonna answer.
In order to set precedents.
I think, okay. Number 8 says, if I believe someone committed an injury to a child, and I heard the punishment range was only 5 to 99 or life, who here would want to give a higher punishment? We've heard of capital punishment before. Number 18, you would say I cannot consider the range of punishment because it is not high enough. Who considers that? Who agrees with that? Number 56. Quickly, tell me, please, sir.
I'm sorry, I can't even hear you.
All right, so everyone, if you do not stand, the court reporter cannot hear. And whatever you're saying, if the court reporter can hear, it's like it never happened. So everyone, if you're not in this box on this front row and you need to stand so the court reporter can hear.
Yes, sir.
He just basically took the whole life and went out and his life.
Okay. Okay. So is it fair to say number 56 that you could not be fair and impartial on punishment because I would consider the range not high enough? Okay. Who agrees with 56 and 80? $22, 24, 18, 14. Yes, ma'am.
We're kind of at a big range, right? Like injury to a child or death to a child, correct? We're answering both. So the situation hypothetically could be extreme of.
Well, I think that the point that was made is if I believed someone committed an injury to a child, if I believed it and I believe the state proved each and every element beyond a reasonable doubt, if I believe that, I could not consider the range of punishment because I don't think it's high enough.
Just clarify, just injury, not something that results.
Correct. Correct. Did you have? No, okay. So what number did I leave off at? 24. 24, thank you. 37, 38. 53, 68, 67, 66.
Because I'm going back and forth with everything I'm hearing. If it's beyond, if the defendant is habitual, if they cannot control themselves, if the child is dismembered or is passed, that's where I would believe that, yes, I would definitely think that this is not enough.
This is not it. Okay. Who else?
Is the term, excuse me, is the term called capital
We're not.
All right, let me
talking about
pause,
the case in
counsel,
this-
let me pause you for a moment.
Okay.
Everyone, this is not a capital punishment case. The range of punishment is probation, 5 years to 99 years or life, probation, 2 years to 20 years, probation, 3 years to 10 years. I'm sorry, thank you, 2 years to 10 years. Those are the range of punishments. Probation in every case are either 5 to 99 years or life, or either 2 to 20 years or 2 to 10 years. As a judge, I follow the law. If it's not in the range of punishment, guess what? It's not in the range of punishment. If somebody wants to change that, then you need to talk to your legislature. So what we're dealing with in this case is the range of punishment for each one of those, anywhere from probation to 5 to 99 years or life, or probation from 2 to 20, or either probation from 2 to 10. Does everybody understand? You may continue. You have 10 minutes, and I paused you whenever I've spoken, counsel.
Okay, thank you, Your Honor. I think there was a few numbers I didn't catch. I don't think this range of punishment is high enough. Did I miss anybody? Okay. Number 38, can you talk to me a little bit about your feelings about that?
Not too sure. Like, I want to make them learn from their mistake.
Okay.
You know.
Punishment.
Yes.
Okay.
Make a point, like, you know, if a child's gonna act up no matter what. But it's like you can't control your own temper. So if something is in a low range, like, you're not making up for your, you're not learning. Is what I'm, yes, that's.
Okay. Okay. So is it in a case where you believed the state proved an injury to a child was committed, if you believed it beyond a reasonable doubt, you cannot consider the low end of the punishment? Okay. Okay. Anybody have any thoughts about what they heard from juror 38? I just can't do it. I just cannot consider the low end if I believed an injury to a child was committed beyond a reasonable doubt. And I think we touched on it a little bit, but if you have some more thoughts on it, or you want to approach, if you have a personal experience of abuse, I would ask, may I ask if you yourself were a victim of abuse? Number 14, 7, 18, 20, 22, 53, 60, 61, 65, and 70. Is being.
Excuse me, counsel, you have someone over here?
I'm sorry.
I just wanted to add on to that. It's not myself, but my wife is a victim of childhood physical abuse. I also have 2 daughters, one's 3, one's 7, and just, you know, all that combined, I have bias. I'm not sure if I can.
Thank you for sharing that. I appreciate that very much, because these are not easy things to talk about. They're not easy things for us to talk about. They're not easy things to hear. So if you were a victim of abuse, would you agree that this is the kind of case you could not be fair and impartial on? Would you agree? If you were a victim of abuse, I can't be fair and impartial here. 14, 18, 22, 53, 61, 60, 65. Anybody else? 37, 48. Anybody else? Did I miss anybody else? Man, what is your number? You said had missed the count there in the pink shirt. Yes, 75. Okay, thank you. Many of you feel that physical pain is not a valid form of punishment. I say physical pain is not a valid form of punishment.
To the child?
To the child. Who agrees? Who agrees? Because we agree a spanking causes physical pain, right? That's kind of the point, right? Okay, so who agrees? Physical pain is not a valid form of punishment. Number 4, 6, 7, 11, 12, 15, 17. Are you raising your number? Or I'm putting you to sleep, I'm sorry. 18, 19, 20, 22, 32, 37, 45, 46, 58, 39, I'm sorry. Yes, ma'am. Yes, ma'am. 39. I agree. Physical pain is not a valid form of punishment. Did you agree?
Not valid, reasonable, or acceptable.
Yeah. 54. 48, did you have something? Did you want to raise your number?
Yeah, I do want to say.
Okay.
Anybody else? I'm offended by this line of questioning. In the way that it's being presented. I feel that when Brittany was talking, it was very hypothetical and it was an overview. And it feels like we're getting into specifics in a case that we've never heard all of the testimony and all the facts. And I think people are going, I don't know, I think it's going beyond what should be passed. I don't know if that's just me. But I really-
Well, let me respond to that. Because if I personally offended you, I apologize. And I will also say that this is the only time that I get to talk to you. And yeah, I'm kind of doing a little bit of a deep dive. I am. And I'm sorry, very sorry if it creates some discomfort. That's not my goal. We're trying to impanel a fair and impartial jury in this case. I don't know if that satisfies you, but did you have a thought about the infliction of physical pain as a valid form of punishment?
It's a hard statement for me to understand the way
Okay.
that it's said. I don't.
Well, timeout doesn't cause physical pain, correct? Spanking does. Spanking does cause physical pain. Would you agree with that? Okay. So think of it in that way, I guess. Timeout, denial of privileges, curfews, no TV, can't go to a birthday party. They were, those kinds of punishments that are not physical versus spanking, pinching. I think spanking is the one, of course, that comes to mind the most, all right? It's some kind of a swat or spank, which causes physical pain. So I hope that clarifies. So I'm asking, who thinks inflicting physical pain is not a valid form of punishment? Okay, and I think we've covered number 50, 58, 65, 62, 75, 74, 73. Number 50, yes.
There's a degree to the spanking. You can just spank them and they can feel pain, yes. Or you can like really hit them out of the, you feeling frustrated with them or angry with them, and you would do more injury to them. So I mean, that's where I come into that, what you're asking. As
Well,
far as the,
tell me if I'm hearing you correctly. You're saying, I'm not bothered by some infliction of physical pain such as a spank. That doesn't bother me, correct?
no, I mean, because there's.
But if it's, right, okay, but it's still physical
Yes.
contact, inflicting some pain, like you want to get the child's attention, correct?
Yes.
Right, that's the point. Okay, so you're saying if it goes beyond that, if it's too severe, then I would never agree with that. Okay,
All right, time.
thank you so much, very much. Does anybody here want to approach the judge?
All right, ladies and gentlemen, this is what we're going to do. We're going to take our lunch break at this time because the court reporter needs her lunch break. So I'm going to ask you all to take your items with you. And it is 1:19. So we're going to be back at 2:30. So there are plenty of places that you can go and have lunch. There are places downstairs. There are places within walking distance. These are my instructions. You now know which case you have involved for jury selection. You are not to Google. You're not to do any research. Does everybody understand?
Yeah.
So you're not to Google anybody's names or look at anything about this case. Does everyone understand? And make sure that you keep those badges on saying that you're here for jury duty, because sometimes what ends up happening is attorneys are walking about the courthouse and they'll be talking about cases because sometimes they want advice on certain things or people will ask them questions. If you hear anything about this case while you're on your lunch break, walk away. Does everyone understand?
Yes.
Is there anyone who does not understand my instructions? Is there anyone who cannot follow these instructions? All right, so which courtroom are you in?
187.
What floor? Who's the judge? So going to be back here at 2:30. All right, and take your personal items with you this time, but leave the cards behind.